So welcome to FIQH with Ben Siamar Mohammed. Like always, each Wednesday, I give Islam today, Islamic law. For Islam, God is the ultimate lawgiver. The Shari'ah is sacred law. So, law, Arabic, Shari'ah. Or the law of God. The term Shari'ah originally signified the way to a source of water. This is the term literally. Metaphorically, it came to mean the straight way to that leads to the faithful to paradise in the hereafter. Muslims believe the Sharia to be God's plan for the ordering of human society. If you have questions later on, I will stop each quarter an hour. I will speak about if you have remarks. It is understood not as an abstract system of ethics or moral philosophy, but as a practical way of life. This is Islamic law. In theory, Islam is a nomocracy, which means a government of laws, not of people. Ideally, the purpose of an Islamic government is to ensure that God's law is followed in human society. The failure of a Muslim government to accomplish this purpose does not absolve the individual from the obligation to live his own life in accordance with the Sharia and to urge others to do likewise. On the Day of Judgment, every person is to be judged by the extent to which he or she has endeavored to fulfill this purpose in this life. Within the framework of the divine law, actions are classified into 5 categories as follows: lawful, halal, which means halal and therefore obligatory; commendable, mustahabb, and therefore recommended; neutral, mubâh, and therefore permitted; fourth, reprehensible, makrûh, and therefore disliked; and last, unlawful, harâm, and therefore forbidden. These categories govern all human actions. The 2 demands of the Sharia are acts of worship, ibadah. There are 2 domains, worship, ibadah, and human relations or transaction. This is Islam all about. Worship and human relations, ibadat and mu'amalat. Ibadat can be seen as the acts of ritual and duties of worship, 5 pillars of Islam, and there are ancillary rules. Differences among the various legal schools are for the most part due to different interpretation with regards to the domain of mu'amalat, relationship, human relationship. These regulations govern personal conduct regarding food and drink, dress, and general behavior. They also cover family and social relationship, business transactions, and international and interreligious relations. So we speak about the roots of fiqh. Sharia is law. Fiqh is jurisprudence. This important distinction must be made between Sharia and fiqh. Fiqh or jurisprudence is the process of human comprehension, interpretation, and codification of the Sharia or sacred law. A scholar who specializes in this science is called a faqih, a jurist, in plural fuqaha, jurists. Islamic law, as it was developed in the legal schools, is based on 4 sources. First one, the Quran and Sunnah of the Prophet are the primary sources. The other 2 are formal sources based on personal reasoning or the scholars' ijtihad. Ijtihad, which means also jurisprudence, so comprehension, interpretation, and codification of the law. So the other two are formal sources based on personal reasoning of the scholars, ijtihad, involving analogical reasoning, qiyas, and general consensus, ijma'. So analogical reasoning, for example, beer, it doesn't exist in the Quran. It's not mentioned in the Quran. But alcohol, wine, is mentioned in the Quran. And wine and beer, they have the effects. So conclusion, beer is also forbidden because it contains alcohol like wine. This is just an example. And there is a general consensus. If a lot of fuqaha, lot of scholars, they made a consensus about something, about a subject, it's taken as obligatory. The process of analogical reasoning consists of 4 methodological steps. The first is to find the text in the Quran or Hadith pertinent to the new case of problem facing the jurist. The second is to discern the similarities and differences to the conditions surrounding the judgments in the 2 cases. The third step is to allow for such differences in making his judgment. The final step is to extend to the rationale of the Quranic or Hadith judgment to cover the new case. Not surprisingly, these principles presented many difficulties and differences of opinion between the jurists. The principle of consensus, ijma', is meant to ensure the continued authenticity of the 3 other sources. Consensus has remained the final arbiter of the truth and error. But even this principle has been subject of many debates among the scholars of the different schools. At the heart of the debate have been the negative consequences of consensus. For a while it preserved the integrity of the shari'ah. It has arrested the development of Islamic law by making ijma' so sacrosanct that no change was possible after the establishment of the major Sunni legal schools. The result has been that Islamic jurisprudence became a thick wall protecting Sharia, but largely depriving it of adaptive and dynamic moral and spiritual role in Muslim society. So B, we speak about the early jurisprudence. The Quran calls upon Muslims to choose a group from among them to dedicate themselves to the acquisition of religious knowledge and to instruct their people when they turn to them. Quran 9:122. The need to have such a group was felt from the beginning as a tribe, settlement, and cities in Arabia, including Mecca, became Muslim domains. Governors with special religious knowledge were sent by the Prophet to administer these new domains and instruct their people in Islam. As the Muslims' domain expanded through a rapid conquest, the need for a uniform body of religious law became increasingly evident. For a time, it was filled by Muslims of the first and second generation, the companions and their successors. They laid the foundations for subsequent legal traditions. Until the 8th century, these traditions centered in Iraq, especially in Kufa and Basra, and in the Hijaz or Western Arabia, particularly in Medina and Mecca. It was in these centers that the living tradition of jurisprudence was transformed from an oral to written sciences. C, third, the Sunni legal schools. By the middle of the 8th century, so because we speak about the Sunni legal schools and one Shî'î legal school. Because Shî'î, they have only one, especially the 12th Imami. So by the middle of the 8th century, the process of establishing distinctive legal schools with independent legal systems was well underway. Two men in the 8th century and two men in the 9th distinguished themselves as the jurists of their time and founders of the earliest Sunni legal schools. After a period of often violent conflict, the four principal Sunni legal schools gained universal acceptance as true and equally valid interpretation of Shari'ah. They divided the Muslims' world geographically among themselves. First school, Hanafi law. Abu Hanifa died 767. The son of a Persian slave, was the most famous jurist of Iraq and founder of Hanafi legal school. He left no written sources that can be ascribed to him with certainty, but his two disciples, Al-Shaybani and Abu Yusuf, developed their master's system into the most impressive and widespread Sunni legal school. Abu Hanifa also showed great reliance on rational thinking and living tradition. He resorted to the two principles of analogical reasoning, qiyas, and rational preference, istihsan. The Hanafi school was for centuries accorded state patronage, first by the Abbasid Caliphate of Al-Khilafah Al-Abbasiyah, and then by the Ottoman Empire of Al-Imbratoriyya Al-Uthmaniyya. It spread to all domains influenced by those two empires. Egypt, Jordan, Lebanon, Syria, Iraq, Central Asia, and the Indian subcontinent, Turkey, and the Balkans. They are all these countries adopted Hanafi school until nowadays. Second school, Mâliki law. Malik ibn Anas died 795. The scholar of Medina. Medina is in Al-Hijaz, in Saudi Arabia, Kingdom of Saudi Arabia nowadays, and founder of the Mâliki legal school, developed his system in the framework of collection of hadith and legal tradition. His book Al-Muwatta, the leveled path, Muwatta means the leveled path, was the earliest collection and reflects the early development of legal thought in Islam. Unlike later jurists, Malik gave equally weight to the Prophet's Sunnah and the practice of living tradition of the people of Medina. He also showed far greater reliance on the efforts to deduce well-considered legal opinion ijtihad than later distinguished religious scholars. He was guided in this effort by the principle of common good, maslaha. If it's something, if it's good for the Muslims, we take it. That was different, just to mention the difference between Malik and Hanbal, which we will speak about a few moments later. Ibn Hanbal, he says no, he take only the text. If he have a text, even if the text is weak, he don't take anything, any other thing. Not like Malik, he takes also common good, maslaha, something which not mentioned in the Quran or in the Sunnah, as if it's good for the Muslims, he take it. The work of both Malik and Abu Hanifa indicates that the principle of prophetic tradition, Sunnah, as a material source of jurisprudence, was still in the process of development. The Malik school was carried early to Egypt, the Gulf region, and North Africa, and from there to Spain, West Africa, and Sudan. Spain in the time of, in the Middle Ages, not Spain nowadays. 3. Shâfi'î law, a decisive state in jurisprudence, came in the 9th century with the crucial work of Muhammad bin Idris al-Shâfi'î, died 820. Systemizer, although he was closer to the school of Medina, he traveled widely and studied at different centers. He is born in Iraq, but later he will live second part of his life in Egypt, and we will die there. He spent his last years in Egypt where he wrote the first systematic treatise on Islamic jurisprudence. His work radically changed the scope and nature of Islamic jurisprudence. Shâfi'î advocated absolute dependence on the two primary sources of Islamic law, the Quran and Sunnah. He based his own system on vast collection of hadith and legal tradition, entitled Kitab al-Ulum, which he compiled for that purpose. Shâfi'î restricted the use of qiyas or analogical reasoning and rejected both the Hanafi principle of istihsan and the Mâliki principle of maslahah. He preferred hadith transmission on single authorities to personal opinion. Shâfi'î saw himself not as a founder of a new legal school, but as the reformer of Islamic law. The Shâfi'î school took root in Egypt, where his founder lived and died. It then spread to southern Arabia and then followed the maritime trade routes to East Africa and Southeast Asia, where it remains the dominant legal school. Southeast Asia, I speak Indonesia, Malaysia, Singapore, all these Muslim countries. Fourth and the last Sunni school, Hanbali law. Not long after Shâfi'î, Ahmad bin Hanbal died 855. His strict conservative founded the Hanbali legal school, strictly in conformity with Shâfi'î's dictum. He produced one of the standard hadith collections, the Musnad, named the Musnad, on which his legal system was founded. The Musnad of Ibn Hanbal was arranged not by subject as other standard collections were, but by the names of the primary transmitters. Though it is not the first work of this genre, it is by far the largest and most important. Hanbali school has had the smallest following, but also disproportionately great influence, especially in modern times. It exists only in Central Arabia, the present Saudi Kingdom, with scattered adherents in other Arab countries. Revolutionary and the reformers, however, have championed its conservative ideology since the 13th century. Derek, I will, if somebody else are here with me, I will stop here, and if you have a question, please ask them, please.
Well, no question for now, I think.
So welcome back to FIQH, Mohammed bin Sa'mar. Now we will speak about the end of ijtihad, the end of jurisprudence. Because with the establishment of the major Sunni legal schools by the 10th century and by a sort of undeclared consensus, the gate of ijtihad was considered to be closed. This did not mean that Islamic thinking ceased altogether. It simply meant that no new legal systems would henceforth to be tolerated. In fact, this process of exclusion began earlier. It depended on the awarding of political patronage to some schools and the denial of it to others. From this time, ijtihad or jurisprudence was limited to the jurisconsults or muftis of each city or country. To this day, like maybe you already heard of it, mufti continue to issue legal opinions called fatwas. And in the media, it has a negative connotation, fatwa, you know, but fatwa, it's just jurisprudence. It's called from jurisconsults. It is called fatwas in accordance with the principle of their respective legal schools. Collections of famous fatwas have been made, which serve as manuals, especially for less creative or less able muftis. And now we arrive to the Shî'î legal school, Ja'fari. This Ja'far as-Sadiq, the 6th Shî'î Imam, was especially revered as descendants of the Prophet, Ahl al-Bayt. He lived in Medina and was one of its leading scholars. He is regarded as the founder of the Shî'î legal and religious system, which bears his name as the Ja'fari legal school. He and his father are venerated for their learning and piety, but in spite of their role in the development of Shî'î legal and theological thought and devotion, they left no written books of written works. 12th Imam Shî'îsm crystallized into a legitimate legal school in the 10th and 11th centuries under Buwaid patronage, al-Buwaydiyin, which is closest to Sunni orthodoxy, in contrast with Sunni tradition, which developed first science of jurisprudence and then a canonical hadith tradition to support it. The Ja'fari or Imami school based its legal system on a vast hadith tradition, transmitted from the Imams over a period of 3 centuries. The essential point of difference between the Shî'î and the Sunni legal tradition is the Shî'î's fundamental belief in the necessity of Imams as guardians of the shari'ah and guides of the community to its correct interpretation and implementation. The earth, following them, cannot be without an imam. He manifests and he is active in the management of the affairs of the community. He can be also hidden, like the last imam, which we mentioned last week, or he can be hidden from human sight and perception. Yeah. So ijtihad or jurisprudence is defined not so much to formulate new laws as to comprehend and interpret the imam's rulings in ways that would apply to new situations. The Imami Shî'î legal school rejected analogical reasoning, in contrary with the Sunni traditions, as an instrument of ijtihad. This does not mean that the region came to play a secondary role in the growth of Shî'î jurisprudence. On the contrary, the primary sources of law were very early defined as the transmitted tradition naql, including the Quran and human region, aql, and where transmitted tradition and region conflict, region takes priority over tradition in the scholars' effort to resolve the conflicts. Ijtihad has remained in principle a primary source of law for Shî'î jurists to the present. But also operative has been the principle of precaution, ihtiyat, which is based on the fear of error in judgment in the absence of the imam. Precaution has tended to minimize the use of personal regions so much that jurists with any measure of originality are feud. So I stop here today, Derek. Next week we will speak about philosophy, Islamic philosophy. And when we finish Islamic philosophy, we will speak about Quran. So this just an introduction, because there is a lot of things to discuss in Islam, but we make just summary of things. I think you understand. If you have question, you can mail me or just ask them directly. Okay, I stop here. If you have a question, please